Okay, well, welcome everybody. Please get seated. Welcome, this is a panel about the European health data space. My name is Sjaak Nout and I work for the Dutch Medical Association. And the Dutch Medical Association is a member of the CPME, which is the Standing Committee for European Doctors. And apart from the Dutch Medical Association, 27 other national medical associations are a member of CPME, and CPME is organizing this panel. It's my great pleasure to be here today to discuss the role of ethics on behalf of the European in the European health data space on the initiative of the CPME, of which I am also a rapporteur for data protection. We organized this panel because on the 3rd of May this year, so a couple of weeks ago, the European Commission adopted a proposal for a regulation on the European health data space, as you may know. And the aim of this regulation is to establish the European health data space in order to improve access to and control by natural persons over their personal electronic health data in the context of healthcare, which is called the primary use of electronic health data, as well as for other purposes that would benefit society, such as research, innovation, policy making, patient safety, personalized medicine, official statistics, or other regulatory activities, and this is called the secondary use of electronic health data. Now, this legislation is very innovative, and much thought has been put into it by the Commission. CPME welcomes the development of the EHDS to boost research and innovation for the public good. However, the devil is in the details, and we are now going to take a deep dive into analyzing some provisions of this legislation. Now, personal data collected for primary healthcare from primary healthcare providers like general practitioners or from secondary healthcare providers like hospitals via the electronic health records will be linked to an EHDS system, which is called the data space, in order to be used for medical research purposes and policy making, which is the secondary use of these data. This repurposing activity under this new regulation seems not to be based on the data subject's consent. It seems that it will become a legal obligation for data holders to make the electronic data available for secondary use and for health data access bodies to provide access to electronic health data. And a data holder can be a doctor, and the minimum categories of data that is listed in Article 33 are quite wide. They include, for example, electronic health records, genetic data, behavior data relevant to health, among others. And according to the proposed regulation, making the data available includes to register, to provide, to restrict access or exchange certain electronic data. And according to the Data Governance Act, access means data use in accordance with specific technical, legal, or organizational requirements without necessarily implying the transmission or downloading of data, which means that access can also consist of remote access to a data space with health data. Now, another key provision is that it needs to be is Article 33, which was already mentioned, which says that where the consent of the natural person is required by national law, health data access bodies shall rely on the obligations laid down in this chapter to provide access to electronic health data. And from these provisions, several issues can be discussed, and I would like to highlight 4 of these issues. The first issue is the obligation of medical confidentiality. Medical confidentiality for the doctor as a data holder in secondary use of data is very important, but it is not clear how this is respected when the patient's consent is not required, as I learned from the proposal. And the second issue is that it seems that consent no longer plays a role, and this can be problematic in our culture, accustomed to respect patient rights when it comes to comply with their will on the secondary use of their health data. For example, think of the case of someone who objects to a specific type of research or to research carried out by a specific company. Also, think about a situation where patients who do not want their data to be used in research, to prevail this, make use of their right to delete data from their health records. This will have consequences, of course, for the deliverance of healthcare to the patient. How this request would be compatible in secondary use? Now, a third issue is connected to the previous point, that is then the paradox in the regulation that for primary use, a patient can restrict access, while for secondary use, the data will have to be made available and be given access without consent or restriction. And finally, a fourth issue is an ethical dilemma for the doctor, who in general is not allowed to disclose patient's data for research without the informed consent of a patient. And this is a corollary of the Declaration of Helsinki due to experiments made on patients in the past without their agreement. And the compliance with this important ethical aspect when conducting research is yet not clear in the regulation. So, from an ethical point of view, when a patient cannot provide consent, and due to different reasons, we must make use of ethics committees. That's what the CPME has published in the leaflet, which is in the conference bag, on the role of ethics committees in the EHDS, and where we are talking, that's the reason why we are talking about this. The CPME believes that there should be greater involvement of ethics committees in the EHDS. They should be considered as a required institutional structure for accountability when establishing databases concerning health, which will be used for research and policy making. And the current ethical standards should not be diminished. Now, these are all topics, issues that we will address in this panel, and I will introduce to you the first speaker, which of course we are very happy to have him. That is Mr. Guillaume Bic from the European Commission. He's legislative officer at the European Commission, DG Health and Food Safety. He is a lawyer specialized in data protection and biomedical law. He has been working before for the European Data Protection Supervisor and at the National Data Protection Authority of Luxembourg. And previously he also worked as a data protection officer and legal counsel in a public biomedical research center in Luxembourg. And I give you the floor. Guillaume.
Okay, thank you, Jack. So thank you for this introduction and for some of these elements you raised. I will try to address some of them, of course, and also address some of the elements that are of interest to the people in this room. So the first thing I think is going to be important to have a broad overview of what the EHDS does for secondary use. And the first thing is when you say there's an access without restriction, it's not really true. I mean, there is an access, but there is a gatekeeper. I mean, the gatekeeper being the health data access body. So, and these people are not just going to say, you know, you're not going to have a researcher say, oh, I want just this data, and thank you, please give it to me. I mean, there's going to be some form of analysis by one of the main tasks of the HTAB will be, I will call them HTAB now because it's a bit easier, would be to analyze and to see whether, you know, it is of interest, given what the information provided by the researcher, to give access to the data. So that's the first point. So let's try very quickly to recap how it will work. So you are a researcher. I mean, mainly talk with researcher, but you can also be people working in policy making or other of public interest element, or in also teaching, and you're asking for access to some data, to some electronic health data. So most likely you will provide information as requested under the EHDS to the EHDAB, and then the EHDAB will actually review it. So first of all, you can't just, the purpose that you can ask for such data are quite limited. I mean, they're quite broad in some sense, but they are limited to some form of like broad public interest in the field of health. I mean, broadly speaking, when you have the big pictures of what it means. There are some prohibition, and also there, some of the prohibition actually does reflect some of the ethical element. You know, one of the most ethical element, which is do no harm, and one of the prohibition there is, of course, that what you're trying to achieve with having access to the data should not make any harm whatsoever to the people who are providing, who are giving the subject of this data. So this is one part of, for example, of an ethical element that is being trying to be addressed. So as I said, there is this review system. And then it's not just access without restriction. I mean, the researcher will not get the data in their own system, and then you say, okay, well, you just get the data, and that's it. I mean, we hope that you take good care of it, and please delete it when you finish. It's not like that. I mean, you have something called the secure processing environment. So basically, you have a form of indirect access to the data. So you are limited. It's not a transfer of data from the data holder to the data user. It's basically a control access to the EHDAB for the user to do what they're planning to do, and they have to tell to the data permit. It's actually it's a kind of like the legal framework of what they can do, what they try to achieve, and how they're going to achieve it. So there it's going to be important for them to say, okay, I need this data for this purpose, and I will need also these kind of statistical or analytical tools to use them. One also interesting element there, because they don't have a full control of the secure processing environment, is it's not going to be necessarily feasible for them to re-identify the people, because again, it's going to be limited to what they can do, the tool available in this secure processing space. So in some way, the confidentiality of the medical confidentiality will be preserved, because they only get access at the most to pseudonymized data, and of course, the principle of data minimization of the GDPR apply, which means that if you can do without pseudonymized but with anonymized data, of course, the EHDAB will say, well, you asked for pseudonymized data, but I will give you anonymized data because that's what you need to do what you want to achieve. So again, it's overall, it's a system where basically the researcher will have some form of easier access in some way, but with a lot of safeguard and control how it's being done. So it's not like an open bar system in some way. I mean, some people may believe that, but it's not going to be as easy as some people expect. And I think that the longer term role is to acknowledge that all these data can be useful for society, can be interesting to be used, to be reused, and to bring some of interesting insight in the health of a specific individual or the population in general. And what the EHDS is trying to do is to try to provide a more common and predictable framework of access and use of these data throughout Europe. The second point is, what's the role of ethics there? I mean, well, how ethics play a role in this thing. The first thing is, ethics is really baked within it's diffusing the whole EHDS system. And I would like also to thank Melody, who will speak about it, I mean, about the European ethical principle for digital health. I mean, they were very useful to have them at that time with this discussion, because some of these elements that was actually discussed there were brought inside the EHDS proposal. I mean, they were baked inside the system. And just to give you like 2 examples of that, for primary use, I mean, there is, trying to really empower people and having better and easier access and control of their data. And this is also a form of, this empowerment is also giving them, for ethics, it gives them better freedom for the use and understanding how their data is being used and accessed. And I think it's an interesting element, and I think that will bring a lot more clarity for people to understand what really was going on with their medical data. It's not going to be a black box. I mean, one of the principles to provided in this European ethical principle is people should have easier access to their health data. And again, the EHDS is trying to make this happening, you know, to make it a reality through the My Health at EU, where people who like, you know, maybe with a smartphone, you can actually have a look at your health data, and then instead of actually having to take all your file with you, with a new doctor, I mean, you go with your smartphone, and hopefully, maybe at some point, you can say to the doctor, okay, look, this is my health data, and you can easily have access to it. With some security element, of course, with strong identification purpose and everything like that. And as I said, for secondary use, there are some forbidden use which are really, really there. I mean, this is a strong statement again from the Commission and the proposal. You should not do harm. I mean, it's not designed to do things there. So to give an example, I mean, if you want to develop new biological weapons or something like that, of course, you're going to say definitely no. I mean, this is definitely not something we want people to use the EHDS for. But if you want to develop, you know, countermeasure to some non-biological weapon, that may be something of interest overall to people. So there again, it's important to do that. So as I say, it's fused to the system. More specifically, sorry, there's some mention of the ethics committees, especially for the use of pseudonymized data. And you have there it's being mentioned in Article 45(4)(b) of the regulation, of the proposed regulation, where basically if you want to use pseudonymized data, you may need to provide insight about the ethical committee element there, if it's deemed necessary at a national level. So there is some element there. On top of that, at the board level and also at the HDAB level, there is a requirement to take into account all stakeholders, and the ethical committees are mentioned as important stakeholders. Finally, I mean, one of the questions that what you wanted to be addressed is also the interplay with DPA, because we are also here with about data protection here. So what about the DPA? Again, here, the EHDS is there to complement and to operationalize the right being provided under the GDPR. I mean, the GDPR provides some right, for example, to right to access and everything, but it's nice to have a right to access, but it's nicer to have a right to immediate access, or to have a practical way to do it in a practical way, easy way. So yes, I mean, you can have a right to access, but if you're going to say to the doctor, the hospital, you're going to say, okay, this is your data, and it's not compatible, and how I transfer that to my new hospital, yes, you have access to the data and you can transfer it, but it's cumbersome. And what we're trying to do is, by interoperability requirement and things like that, is trying to make it easier, to make it more operationalized. On top of that, on the secondary use, it's clear that under Article 51 of the regulation, HDAB and the data user are defined as joint controller. And what does it mean? Clearly that is DPA will have the supervisory authority against the joint controllers, and the requirement and the element of the GDPR still apply. I mean, it's not there to replace or to modify the GDPR. It's actually, again, complementing what the GDPR is proposing, using the GDPR flexibility in some element, and trying to operationalize them for the use and the reuse of electronic health data.
Okay, thank you. Can I ask you one question? You mentioned that one of the purposes of the EHDS is to enhance patients' rights for having access to electronic health data. Yeah. But it's not the purpose of the idea of the EHDS that patients themselves are going to make their data available is it? It's the health professional that will make their data available for other health professionals for primary use and for secondary purposes?
There's different system at play between the primary and secondary use, and different elements. Again, it's depending on the role, but for secondary use, at least you have the EHDS, which are there to monitor how the data are made available and how the data are being reused. And this is really the control tower of the whole system. Yeah. On the primary use, again, it's more there is a focus for patients and for people in general to have a better control understanding of how data are being used and how they can actually make it more easily available or restrict the use by other professionals. So that's different dynamics being into play to address that. And that's also why I think the two elements are in the same regulation, because there are interplay between these two things. And also with the board, when with the board, you're also going to have a subgroup between primary use and secondary use, but also we're hoping that they are going to talk to each other to see how they can interact and how they can actually address these kind of issues, which are both important both for primary and secondary use.
Okay, but the answer to my question is that the healthcare professional is the one who provides or will make their data from the patient available, not the patient himself.
Well, no, actually the thing is the healthcare professional generate data, the patient generate data, and these are being stored somewhere by data holder. And that the data holder need to make them available by the EHDS through the data permit system.
Right, yeah, thank you. Okay, thank you, Guillaume. We're going now to jump to the second panelist, which is Melody Berno. Melody joined the eHealth delegation of the French Ministry of Health in 2022 as a project director for European Health Data Space. And she was a member of the Committee on Bioethics since 2020. And at the Directorate General for Health, she conducted the 2021 revision of the French bioethics laws for all aspects related to reproduction, genetics, artificial intelligence in healthcare, and management of intersex children. During the COVID crisis, she coordinated the COVID data task force of Greater Paris University Hospital, where she was previously project leader for the secondary use of health data for strategic analysis and management. And Melody will talk about the ethical principles from the EU. Go ahead.
Thank you. Can you hear me? Yes. I have a small voice. That's why I ask. Sorry. So my presentation will be less technical than Guillaume's one. I will be talking to you about an initiative taken by the French presidency of the European Council of the European Union, the French presidency, around the ethical principles. And as you may remember, when opening the French presidency, President Emmanuel Macron stated that he wanted the presidency to be the presidency of relaunch, strength, and European values. So in this idea, many initiatives were taken to put in the center the European values. And besides this, during the pandemic, the adoption of the EU DCC, the COVID certificate, was a major acceleration of the health data use and e-health in Europe. And it was made possible because people united around a same goal and asked themselves ethical questions. So the European values were at the center. So building on all this, the French presidency proposed to the Health Network to reflect on European values and what could be European principles for digital health in preparing the work for the European Health Data Space. So, on a proposal we made in the beginning of January, and working with all member states of the health network, January 26, we adopted 16 ethical principles for digital health. And those principles aim to infuse in the European Health Data Space proposal. So what I would share with you is those principles. And we believe those principles are important because ethic is a guarantee for people to trust what we are doing with their data. And each steps we take with the European ethical principle is a way forward to trust and to acceptance and belief in what we are making with the European Health Data Space. So this is the introduction. You will have the slide if you want. So the first dimension is, so the European ethical principles are built around 4 dimensions. The first dimension is to make digital health based on humanistic values. And the idea is really to extend the major fundamentals of healthcare to digital health especially. That is namely one's will to choose or to consent to what, to how he's taken care of and how his data is used. So the first principle is digital health complements and optimizes face-to-face healthcare. And I really like what Norway said when we work on this principle, because they told us their motto was digitally when possible and physically when needed. That is to say, when you propose, for example, teleconsultation to a patient, he should always have the choice to meet the physician in person. There should not be no difference between the way his care is managed, whether he is seen in teleconsultation or in a physical. The second principle, sorry because I can't see the screen there. Individuals are informed about the benefits and limits of digital health. And that is when you're using some digital health application, some digital health device, you should understand what is at stake, and providers should provide for the information, the right information and understandable information to the patients and the users. Individuals are informed about the functioning of digital health services and can customize their interaction with them. That really relates to all the health applications you can have on for example, on a mobile device, and how many times you will be getting notification. A patient should be able to choose how many times he wishes to have notifications. Obviously, according with his physician on the need for the notification. For example, if you have a diabetes and when your glycemia is low, you will need to have the notification. And the fourth principle for this dimension is when artificial intelligence is used, always enable efforts are made to make it without discriminatory bias. And this principle about artificial intelligence is major because it relates obviously to the European Health Data Space and to the Artificial Intelligence Act in preparation, because the use of AI in healthcare should always be transparent and with a human supervision. The second dimension is about enabling individuals to manage their digital health and data. And this principle directly builds on the study made by the European Commission preparing the European Health Data Space on the enforcement and the application of the GDPR for health data in all the member states. Because this dimension aims to make GDPR more effective and to give power, to give the power to individuals to manage their own data. And this translates by individuals are actively involved in shaping the European and national frameworks of digital health and data. And in France, for example, we organized some comité citoyen, which is some meetings with the citizens, in order to build the system for the primary use of health data and the sharing of health data. And all was made with the individuals. The second principle is individuals can easily and reliably retrieve their health data in commonly used format. So this principle is directly aiming at interoperability, because it's nice if you can download your data, but if you cannot use them in another application or if you cannot print them, it's not useful. The third principle is individuals can get easily information on how their health data have been used and for which purpose. And that is really how, with whom are you sharing your data, with which health professional, and all on secondary use, for which research, for which care management, health policy. And the fourth principle, individuals can easily and reliably grant access to their health data, including objection when applicable. That is, you can choose with which health professional you can share your data, but also maybe with who from your family you wish to share your health data, and be able to do so through a system which offers you the possibility to do so. The third dimension is about making digital health inclusive. And this is really about leaving no one behind, training everyone to use digital health, to fight against electronism, to make it accessible to every kind of disabilities, and to help with the low digital literacy and health literacy. The first principle is about digital health services are accessible by all, including by people with disabilities of low levels of literacy. As I just said, we have some guidelines to develop some systems in order for them to be accessible. They should be applied. That should be mandatory for all digital health systems. Digital health services are intuitive and easy to use. Individuals have access to digital health training. You should be autonomous when you use a new digital health service. That's why providers should provide you with all the information and the material to understand how to get started with the digital health service. You shouldn't be in the need to require a third party or help to do so. And digital health services include support through human communication. And this one is because when you're using some digital health services, often the help is in the digital service and you don't have direct access to a person, a human being who will answer your question. And so this help can be provided in person through an email, through a chat box, but it should be a human behind the email or the chat box. And you should provide for sufficient and opening hours for people to benefit from it. And the fourth dimension, it's when we're very attached, and it's really kind of new in digital health. It's to implement eco-responsible digital health and to promote sober uses. The first principle, environmental impacts of digital health are identified and measured. We believe it's not always the case, and it should be thought of. Digital health services are developed in compliance with eco-design and best practice. Reuse and recycling of digital health equipment is ensured, and digital health stakeholders are committed to reducing their ecological footprints. In France, for example, we have implemented an eco-responsible digital health guide with the ethic department of the health delegation of the French Ministry of Health, and we propose some validated methods to measure your environmental impacts of your digital health services, and we recommend that people are aware of the environmental impact, that is physicians, but also patients and every users. So this is for the four principles for digital health of the European Health Network.
Thank you, Melody, for this overview of ethical principles for digital health. We will turn now to Ms. Annika Eberstein from COSIR. She is currently working as Interim Secretary General at COSIR, which is the European Trade Association, representing the medical imaging, radiotherapy, health, IT, and electromedical industries. Annika is coordinating technical and regulatory activities, including related to the medical device regulation, European and international standardization. Annika.
Thank you. Hello, everybody. So indeed, I am here on behalf of companies that develop software. So medical software that is used to diagnose or treat or manage a specific disease, but also software that is used in healthcare systems to make workflows more efficient for doctors and for nurses and for technicians, but also to provide the IT infrastructure that you need in a healthcare environment. So for example, we also represent the vendors of electronic health record systems. I think I don't have to tell you about the huge potential that digital health and data analytics have in healthcare. You're here, so I'm just going to take that for granted. But I have been asked to talk a little bit about the experience that software developers currently make when trying to do research and development for medical software. And unfortunately, the situation right now in the European Union is that there are many challenges for this type of product development. And of course, if I just go through them one by one, patient consent is critical. We don't have to discuss that. But many of the practical processes for actually ensure that consent can definitely be improved, also due to just the locality of the processes. Just getting access to the data right now, due to the fragmented nature of databases right now, between institutions, between member states, between regions, is very, very difficult to do in a legal and an ethical manner, which should be the ambition, I think, for everybody. Then, again, for this audience, of course, the GDPR has not led to one harmonized European legislation. We do see fragmentation, and which puts additional burden also on developers that have to deal with the different national, sometimes even regional requirements that need to be complied with. Again, to do this type of research and development in an ethical manner. I think just to give you an example, a concrete example of how it works. So when you have a project where the outcome should be to develop a software that, for example, let's say analyzes images of tumors to aid in the diagnosis of a specific cancer type, that is a medical device under the medical device regulation. Obviously, you start out with a research question. You start out with what do you actually want to achieve, and what kind of data do you need to actually achieve those outcomes. In this case, probably you would need access to images, to medical images of diverse patient populations. And you may also need access to clinical data from electronic health records if you want to connect them via an algorithm to actually then provide support in the diagnosis by the clinician. Once you have done that, you need to identify what really are the legal requirements that need to be fulfilled. That is GDPR, that is patient consent. Of course, it's different if that data is already available and you just use it, or it still needs to be collected by you or maybe an institution you partner with as a company. Ethics committees do get involved, of course, because once you start developing a clinical study, you need to get ethics committee release to be sure that what you're trying to do does fulfill the ethical requirements. And then, again, you got a bunch of lawyers involved, depending also on the size of your company and how many of them you can afford, and try to really hammer out that GDPR compliance is there, that also under the medical device regulation, all requirements are fulfilled to then start a study. And that is then just the start. So at that point, you then start training the algorithm, and then of course, afterwards, you still have to go through the entire certification process under the medical device regulation. You may also have some other requirements, like cybersecurity. That is not the topic of today's discussion. If we think about some, I think that is a very, very relevant example of an ethical concern that software developers are facing, and that is bias. I mean, everybody is now very excited about the potential of artificial intelligence and machine learning in healthcare. We are as well. And one of the first questions that always comes up is, how do we deal with bias by these algorithms? And obviously, bias is something that is inherent to human life. So having an algorithm that is unbiased is a contradiction in itself. But there are discussions to be had and decisions to be taken on what kind of biases are acceptable, what kind of population is the software targeting. Is it an algorithm that should be applicable to as many populations as possible? Does that make clinical sense as well? Or is it maybe an algorithm that is then going to be calibrated for specific populations in specific hospitals or GP practices or wherever the software is going to be used? So these are decisions that need to be taken. And obviously, within the medical device industry, we do have experience with that. So our member companies have been placing safe and performant medical equipment on the market for, in some cases, more than 100 years. We know how this works. So we do have requirements in place and we have practices in place to ensure that ethical concerns are going to be addressed during the product development process. Of course, always in consultation with ethics committees, with our users, with the clinicians, with patients, depending on the intended purpose of the device and who finally is going to use it, as well as with our regulators. We have legislation in place. The MDR has clear requirements when it comes to the performance of a software. And of course, a large part of the performance is what kind of bias does it address? Does it address actually the population it is supposed to address, or is it not? Because if it is not, then there is a clear fault in the software that needs to be improved. But on top of that, of course, there are many ethical considerations that that go beyond also the core legislative requirements, and that is then where the situation becomes very, very complex. So when it comes to the role of ethics committees in this entire discussions, what we would love in an ideal, perfect world is that ethics committees actually become the forum where we can have this type of discussion, where as a software developer, you can go and say, look, I want to develop this algorithm. This is what I want to achieve with it. This is the intended purpose. How can we, what can we do so that we have this trade-off between the bias and the accuracy that we want to achieve? Can you help me? We are not living in a perfect world. I hope that's not a surprise to anybody. And that means that currently these types of discussions are very, very difficult. There are a number of reasons for that. So what we do see in practice is that ethics committees want to do their best, but many of them are under-resourced, both in terms of just general capacity, but also in terms of the skills and expertise that they have. We are entering into a new age, so understanding data analytics, understanding data management is a core skill that will have to be present in these fora. And I mean, ethics committees are organized at sometimes a very, very local level. And we understand that for certain reasons that makes sense, because ethical principles, ethical views do, of course, have a local, national character to them. But if you look at it from the perspective of a software developer who wants to develop that one software that receives one CE mark for the entire European Union, the burden and the time and the resources spent on addressing this fragmented landscape is very difficult to address. So we do think there needs to be some kind of balance where, at least at the European level, we can agree on some principles, even if, of course, not everything can be solved, because there is a diversity within the EU that we are also proud of. And then I think just to finish, I think what is really important is that we should differentiate between the role of ethics committees and then the interpretation and the implementation of the GDPR. Both are fragmented, both are complicated, and we should make sure that at the end of it, we come to at least the attempt of a harmonized framework that allows faster market access and that allows that patients in the European Union have the same access to innovative software as our co-citizens in the United States or Japan have. I'm going to finish at that. Thank you.
Annika, for sharing your view on the role of ethics committees in digital health. Final speaker, before we go to the discussion, will be Dr. Ottmark Kloiber. Ottmar is since 2005 the Secretary General of the World Medical Association. He studied medicine at the University of Cologne and joined the Department of Biochemistry at the University of Minnesota Duluth in 1985. Continued as a research fellow at the Max Planck Institute for Neurological Research, and until 1991 he joined the German Medical Association. There he also worked in various functions and finally left as Deputy Secretary General. He provided advice to numerous governments and parliaments on medical ethics and social medical issues. And Ottmar is going to share his view about the importance of ethical reviews from the perspective of the World Medical Association.
Thank you, Jack, and thank you also for the CPME for inviting me to be here with you today. And of course, as we are an international organization, not only looking on the European sphere, we represent also the physician views in a more global way than only looking for European legislation. Nevertheless, I will show you that it has a lot to do with what is going on in Europe now, and we welcome very much this discussion and also the work of the European Union on getting a legal framework to work there. Although you will probably see that there are some differences in opinion on that. I have no commercial or financial interest in the topic, just to exclude their conflict of interest with that. We are packing this together a little bit also with the issue of biobanks, kind of the analog model of a health database, because we see the same ethical challenges and problems with the health databases and biobanks. Since 1964, there is the Declaration of Helsinki, which is the first international document which regulates experimentation with human beings, research with human beings. Before that, it was more or less a head doctor, a chief doctor, who decided which of the patients goes into a clinical trial where a new medicine was tested. And in many cases, they wouldn't even ask patients whether they want to be on that experiment or not. That, of course, became, especially after what happened in Germany, in my country, an abuse of medicine in the Third Reich, no longer acceptable, and therefore it was time to have kind of an international standard and guideline for that. Since then, it has developed the informed consent, and I will just say a few words on that later on. The use of approval by clinical, by ethics committees, sharing of data, post-trial access to care, all those issues which nowadays in most countries are basic standards, as well legally as ethically, come from the Declaration of Helsinki, which started in 1964. And of course, at one point, we had to question ourselves, is this guideline for research still valid if we are doing research in a virtual world? And is there also a guideline necessary? And we found, yes, it is necessary. And for us, it was also very clear, and when I say us, it's the global community of physicians in this international organizations developing these guidelines. We said it is very important that we would like to keep the big steps forward we have made in the past century, especially the informed consent. Now, informed consent, to make that very clear, is not just having a consent and somebody tells you something about it. Informed consent means that a patient or a person who is taking part in a research must not necessarily be a patient, but a person taking part in a research understands what are the risks, what are the benefits in this research for him or herself being a participant in that, and then being able with this information to understand this information and to take a decision. Now, this has been taken into medicine in general. So nowadays, in most of our societies, a doctor has to tell you what he does with you, even if you agree that the doctor treats you and you want him to treat it, but he has to tell you, he has to explain, and you have to give an informed consent. And that has become a gold standard in order to protect people, in order to protect patients, to protect subjects for that. So when we were talking about databases, we said, well, the informed consent is not to be given up. This is something which we think has been a crucial gain in patient rights, in saving dignity, preventing abuse in the past centuries, so that this should not be given up. But this is difficult when you do not know what are you doing with the data in the future, because it's in a database or in a biobank stored there as material. And we thought there is no quick fix for this. There is no simple or broad consent, as some people say, oh, you give me a broad consent, you say you can do everything you want with the data, and then it's done. And we thought, well, if we have that, then actually we don't need an informed consent anymore, because it voids any informed consent, which gives you the chance to think about the risk and the benefit of that. Second, we found that the discussion about secondary use is actually not very helpful. The term secondary use is misleading, and it can also be a reason for abuse. So what we say is, when you as a patient go to a doctor, you are sharing your information, your data, with a physician and with other physicians and other health professionals, because you want to be treated, you want to be diagnosed, you want to be helped, and that is your understanding when you give data. You give your personal coordinates, you let the doctor measure, and all this data comes into your patient file and is there, and that is probably your understanding when you go to a doctor, that the doctor uses this to help you. You don't necessarily think that you give this data that somebody else does something else with this data. So what we do is we don't speak about primary and secondary use, we speak about use for the actual patient care, for your patient care, and for other uses. So you may think this is academic, this distinguishing, but I'm happy to speak about this a little bit more and explain it in depth why we think it's not helpful. So, and at the beginning of starting a health database or a biobank, you cannot tell people what you will do with that data in a year, in 2 years, in 5 years. There may be many, many uses for that, and it's not possible to describe the risks, and it's not possible to describe the benefits. So the classical informed consent is very difficult, if not impossible to give. And it may be also impractical because you think you put in a database the data and you want to use the database not twice for secondary use. You know you put on the database because you want to use it multiple times, maybe 10 times a year, 20 times a year, 100 times a year, or even more. So asking every time for an informed consent is, in most cases, pretty much impossible to do. And then we also found there is a problem in describing what is research in that world, in the world of using virtual data. Is it actually helpful to do that? Is it upfront for a framework, for a rule, possible to describe legitimate data? We found this is extremely difficult, and of course, for us, very much research prone and interested, research probably is not that much the big problem. It may be, but in general not. It is probably more the commercial, administrational, and political use of the health data, which is there in a data. Let's face it, we have a long history of political abuse of health data, even here in Europe. That's not something alien. It has happened here in Europe, and it has happened even in most recent times. Think about the arrest of us, or the killing of Osama bin Laden. So that was only possible with the use of health data. So we think very strongly that there should be a separation between the individual use and the use in health databases and biobanks, and we should not talk about the secondary use, but should differentiate this for these purposes. So the question is, how can we protect, on one hand, personal dignity, autonomy of the person, and how can we, on the other hand, have a regulation that allows the use of this data? Because I think we all share the idea that health data has huge potential in order to help us to solve health problems and to advance research very strongly. So initial conclusions for us were broad or one-time consent alone is not acceptable. It voids basically the informed consent, which we thought is very important for the protection of the individual. The stringent use of the informed consent is unrealistic because of the frequent use or potential frequent use. A specific solution for research is very difficult and probably unlikely to be made. So we said for every use which is not for the treatment, we want to have a frame and a solution there. We also would like to see that, or see it as a chance, that in use of databases and biobanks, there can be a separation between the data holder and the data user. And this gives you options to protect as well when it comes, for instance, to aggregation and anonymization of the data. So here comes our solution, and the solution is very strong connected to the use of an ethical review committee or an access committee that you have for a database. It should start to question, is this database necessary and useful? Is it in line with our ethical ideas as a community or as a society? Oh, I'm sorry for that. With a society. How can we install then a consent that gives allowance to put the data into a database, which obviously has to be very shallow because we don't know what is going on, but then replace, and this is the crucial idea, replace the informed consent in many cases by a decision of an ethics committee. We do this nowadays, for instance, when we have a study, for instance, of accident victims, where you cannot ask a person whether he or she wants to be in a clinical trial for saving accident victims. Then there is a decision by an ethics committee which tells you you can go forward with that and do that or not. And similarly, we have a situation here where not necessarily everybody can be asked because the data given may be already diseased, it may be too frequent, as I said, but nevertheless, there should be a substitute of this informed consent given by an ethics committee. And an ethics committee may say, your use of that data, whatever that is, whether that is research or administrational or political use of the data, does not inflict any risk to the person, and you can go forward. It may say it may an influence on the person who has given the data, and you must take additional safeguards. For instance, anonymization and aggregation in order to protect people. It may in the end, because anonymization and aggregation may not be suitable for a certain study, say, sorry, but you will have to ask the persons who gave you the data by the meaning of a real informed consent that still has to be provided. So there is a multi-layered concept of an ethics committee having a role in the establishing the governance of a database or a biobank, and finally in the use of the database or biobank, whatever the use is. It should be then decided by the ethics committee whether the protection that has been installed by the governance of the database and the initial consent that has been given is enough, or whether additional measures have to be taken. You will find this all in the Declaration of Taipei, which complements the Declaration of Helsinki. This is a document from 2016, already 6 years old now. It gives the ethical considerations regarding of health databases and biobanks, and is at the moment the international standard for the professional deontology for physicians. Thank you very much.
Thank you, Ottmar. I think it is time to give the floor to the audience. We have now heard information about the proposal and the ethical principles and the role of ethic committees and perspective from the World Medical Association. If you have a question, I would like to ask you to wait for the microphone, which Sarah will bring to you. Please stand up and say your name and your organization.
Hello, my name is Marco Flora. I'm a PhD researcher at the University of Groningen. And I would like to ask you what you think about the idea of dynamic consent as an alternative to the consent that we have now, which is more of a one-time action. And if you see it as a future solution in the context of the Data Governance Act and the altruistic consent form that will be developed by the Commission. Thank you.
Your question is directed to Ottmar, I presume?
Yeah, should I answer directly?
Yeah, please.
Yes, I think it is necessary to think about different models of consent, which are currently being discussed: layered consents, dynamic consent. Not all of them may be applicable to all of the use scenarios of databases and biobanks. For instance, frequency may be a point of concern with that, and it may be that, for instance, a lot of the data can be used without any further action, because simply you can exclude that there will be any repercussions to the data given. But I think that these new models of consent certainly have to be explored. Let's face it, and let's be truthful about it. What we have currently as informed consent, to a large extent, is so legalistic, so bureaucratic, that it becomes, in many cases, completely useless, because nobody understands it, nobody can read the 30-page documents which you have to sign. So I think that new types of consent have to be developed. Currently, that is legally not possible, simply because those models will have to be developed and will have to be legalized, so to speak, but I'm pretty sure this will come.
Okay, thank you. I suggest that we start in the back, and then here in the front we have 3-4 questions. Oh, over there.
Thank you. So I'm Audrey Deken I'm a PhD student from the University of Lille. My questions are mainly directed to Mr. Beek, as he presented to us the the health data space. So basically, it's to what extent are going to be checked or verified the algorithm before the grant of the access to the data. I mean, because we could trust everybody, but we can also assume that maybe a company or somebody would have interest in different fields, let's say. It could be health, but also insurance or anything. And are you going to grant access the same way to European stakeholders and other stakeholders? So that's my questions.
Guillaume, I guess? Can you answer that?
Yeah, but I didn't follow the whole thing. So what's about the? I didn't follow the whole. I didn't hear the whole.
Your question was how can you grant access to the health data of the citizens, for the citizens? Yes?
There are two things. There is one is...
Oh, use the microphone behind you. Yeah.
One, this is the European database. Do we grant access to Europeans or to the whole world with the same condition? That was
okay.
one question. And the other question, I think, is do you check also the algorithm that will be used in the research project? Because some could be used to extract data and feed insurance database or whatever.
Yeah. Okay. Okay.
No, it's a bit better. Thank you.
Yeah.
So, more or less, okay. Okay, sorry. So in relationship to the data user, there is no limitation. I mean, you can be someone from from third country and can request access to the data through the EHDS. So there's no limitation there. That's the first one. For what you can and you can't do, of course, again, through the secured processing environment, there are limits to what you can do. And there is a strong obligation not to try to re-identify the person or try to game the system and to say, okay, I'm going to ask for that, but basically what I'm trying to do is trying to get the data anyway and trying to do something about it. I mean, normally there are some technical elements to prevent people from extracting the data outside of the secure processing environment. And through the EHDS, the only thing you can actually get out of the secure processing environment is anonymous elements. So either, for example, if you have an AI solution, you actually download your AI solution from the system, and the AI solution just say, yeah, I do work with this kind of data, and I can actually work with it. But you cannot you can maybe re-upload the AI solution, but without any of the data that being used and everything like or anything like that. So really, only anonymous element can be extracted, can be coming outside of the secured processing environment.
Okay, is that answer to your question? Hilke.
I got the microphone. Comes a very interesting discussion, more and more, I think. Also, suddenly I thought this is also about data transfer of sensitive data to third countries, basically. But my question is another one. You talked, Guillaume, a lot about the role of ethics committees. Also, Melody talked about this. But what exactly is their role? If a data user wants access, does he have to pass by an ethics committee? What is the role of, for instance, a data protection authority? Is there still a role of that? How is it checked that, because everyone can say, I need your data because I have a very good idea, but how can you check that it's not used by biochemical weapons, to one example you mentioned? So who is actually ensuring that there is some control over the personal data, if they're still personal at least?
That's the thing. You are checking the system is being controlled within the secure processing environment. So you are the HTAB will ensure that only necessary data are being used, only the necessary tool that you need to do your what you want to do through the data permit. I mean, basically you have a data permit saying, okay, you have the right to use this data to identify, let's say, for example, trying to identify a new gene involved in blood cancer. So that's what you're going to get as the tool available, the data available to the system, and what you can get out is basically to say, okay, we have identified that this gene is responsible for an increase of 10% of the of risk in blood cancer or something like that. So again, it's there is. The system is being controlled by the EHDS, so it's not like I give you the information to the data user, and we hope for the best that they will do what they say. There are some form of supervision of what's happening within the secure processing environment.
Form of supervision. Who is supervising this? Who is the one in charge supervising it? You say there's some supervision that the data will not get out, or only get out real for good purposes, for real. Genuine, ethical, right purpose, but
on top of that, I mean, just to say, the data user have to provide at the end of the project provide information to the EHDS about what the outcome of the project. I mean that first for the EHDS to check what they've done correspond to what they ask, and for second reason also it's for the EHDS to be able to publish this information. So everybody can actually see that basically information being provided and reused within the by the EHDS, how actually these are the kind of outcome you get, the positive outcome you get out of these research studies.
The EHDS is the Health Data Access Body, as national,
And because it's a mouthful to say.
which every member state should have.
Yeah, sorry about that.
Data access body is something different than the data protection authority. That's something different than the data protection authority.
No, but they're not data protection authority. I mean, the data protection authority have the role. As I said, they are HDAB and data user are joint controllers, and of course, because of the GDPR, they will be under supervision of the DPA as normal under the GDPR.
Okay. Next question, please.
Hi, I just wanted to stress that I completely understand Anika, because the situation right now, the level of stratification on different laws, because the power of this member state that use their power of discretion about the use of sensitive data, especially in Italy, that is the place where I work and live, is dramatic, and there is no possibility to escape without contradiction. So I hope that this new proposal will help the use of health data for scientific research, because we are still thinking about specific consent that is something that doesn't protect the patient, and the measure, technical organizational measure will protect the patient. The system of governance, real involvement of the patient in the use of their data will protect the patient, not the situation right now. So I really think that, I really hope this new proposal will help the biomedical research and would not add another layer of complexity.
Okay, point taken. Thank you.
Thank you. My name is Tamar Sharon. I'm a philosopher, professor of philosophy and technology at Radboud University in the Netherlands and a member of the European Commission's EGE. I wanted to pick up on what I think is a concern that's circulating here that still remains, and that's about the level of access restriction. So I'd preface this by saying that I am running a research project that looks at the increased involvement of big tech companies in biomedical research and healthcare provision as well. This is something that's been going on for almost a decade now, also in Europe. And what we're seeing is that some of the risks, there are of course obvious privacy risks, but there are kind of broader societal risks about how these companies may be reshaping a sector like health and medicine in line with some of their interests and values, and what kind of new dependencies are being created on these companies for laying down the digital infrastructure for doing biomedical research in the future. What I understand from what Guillaume, you're saying is that access is restricted basically on principles of do no harm, so I understand this as patient safety, and research in the public interest. Now, both of these principles are, I would say, quite well covered by these companies. So they're not seeking to do harm, and they are not doing research which is not in the public interest. So they're collaborating on things like Parkinson's research and all kinds of public interest type research areas. So what kind of access restriction would be in place if Google knocked on the door and said they would like to access the European health data space? And based on what principles? That I think is perhaps the concern that was being raised here, and that I'm really seeing in the research we're doing, because these companies are already in there doing research with data that's generated at public research institutions.
As I said, I mean, basically, you have a list of purpose, and you have a list of prohibited purpose. So you have, first of all, as other users, they will need to show what the type of data they want, for what kind of purpose they want, and to go through all the elements that required to request a data permit. And then it will be for the health data access body, the EHDS, to review that in light of what are the requirements of the regulation. I mean, as I said, there are also two limitations. I mean, big limitation there. The first one I said, they do not control directly the data. They are still within an environment controlled by the EHDS. So they're not a direct control of them. You know, they just don't get the data directly, and then they do what. Then we have entrusting them to do what they want. The second thing is, and this also is quite important, these databases and these access and everything are not permanent. I mean, you have like normally within 5 years. I mean, you have a limited access to these data. So you're there also for.
Google knocked on the door and said, I would like access to the data space in order to do research on Parkinson's research, for example. In the controlled space that is there, they would be allowed access. Is that correct?
Provided that they comply with what the EHDS requirements are.
Okay.
To a permit. But they, as I said, I mean, they don't have full control of the data. It's still within. They don't get the data. They don't get the data for that. I mean, they only get the data for doing this little piece of research or whatever they want to do.
Okay. Yes. Next question.
Elisabeth Steindl, University of Vienna. I have a question regarding the ethical principles that we heard by Melody, and it is about if you could elaborate on the future of these principles and the implementation that is foreseen for them, and if there is, since it is a sort of soft regulation tool, if there is some hard law component to it. Thank you.
Yeah. Yes, go ahead.
Okay. Oh, sorry.
Just speak. Just
okay.
talk.
Thank you for your question. Obviously, the European ethical principles are not legally binding, but the Commission did hard work reviewing the EHDS proposal at the light of the principles, I believe. And so they infuse in the proposal, but also we want to take a step further in concrete actions, in concrete implementation of the principle. So we're working with the eHealth network member states on a supportive document for the principles. It will include detailed explanations and use cases from all member states. And we will be discussing in our next plenary session what we want for the next steps in the second semester.
Okay.
I'm a data protection lawyer in clinical research and life science sector. So I welcome the idea to bring ethical point of view with the ethical committee, but my concern is the following: across EU member states, we have like many ethical committee, and here we are talking about a EU project. So how will you designate the competent ethical committee to address the authorization? Will you like do some kind of task force at the EU level, or will you, for example, I don't know, put some criteria to designate which ethical committee will tackle a specific demand? Thank you.
Okay, who can answer that question? Yes?
Can I try?
Yes, sure.
You probably know the Silver Book of the WHO for the ethics committees. and which prescribes kind of an ideal idea on how an ethics committee should be structured, which competences should be there. I think this will have to be developed for this as well. Maybe it will have to be a separate set of ethics or access committees, which have been described also, or also described by the European Union, then which describes competencies and how these committees should be set up. For me, it would be also important that states have to understand that these committees have to be independent, that they have to be staffed as well, that they have to have the resources to do the work. Because I think the lady also asked the questions about the algorithms which are there. In plain English said, how do we make sure that the ethics committees understands what they are looking into? And I think that is really a challenge for this new type of research. But on the other hand, let's face it, let's first learn how to walk, and then we will learn how to run. So there will be one step after the other, and in this period there will be a lot of experience and maybe also a change and adaptation of rules, which we will have, and certainly the requirements for the ethics committees. But you are right, it is a problem. It is already a problem with the current research committees.
Okay. Final question.
Hi, thank you. I have one point and a question to make. Just following on this discussion about new models of consent that was made. So I work in an institute that supports Biobank in South Tyrol in Italy, and we work in a very restrictive consent model for research. But since 2011, we have been using dynamic consent as our consent model. And it is fine. We do not need any new legal provisions for that. It is within a legal and ethical framework that already works, and it works very, very well for us. It's a participant-centric approach that works incredibly well. On this point, what that was made here about Google, I think we've had a lot of conversation about access, but there is no conversation about the downstream access. So what are we going to happen if the likes of Google are going to come in, collect our data, monetize that data, create a therapy without any guarantees of downstream access to that data or that therapy that has come from our data. We saw it with COVID. A lot of public money was spent and invested into the development of therapies that many people haven't access to. So I think there is no conversation with regards to if we're going to be making this data available, how can we share justice and access in the downstream uses of that data?
I believe that it's also possible to give remote access to data so that you do not
No, what I
download.
mean is the downstream benefits. So if we're giving access to companies, how can we guarantee and ensure that there is downstream access to the therapies that has come from my data? If Google is going to be given access to my data without my consent, how can we ensure that I get access to that, the benefits of that therapy?
Okay, Ottmark?
Yeah, in the Declaration of Taipei has an answer to that question. The answer lies in the setup and the construction of the database that has to describe its governance and its processes, which will be part of the information that has to be given for the consent that has been given. And this may have or should have a very clear statements about the question of benefit sharing. Not only for the databases, but also for the participants who give data if necessary, but also to such questions, for instance, what happens if the database is terminated? What happens with the data? What happens with the ownership of the data? What goes on? All those questions have to be described in these government regulations, which should be the question for the first an initial testing of setting up a database, and then also should be described before a person gives consent to put the data into a database with that.
If I may also add to that, because I think your question is not only about access to data, but actually access to software, because at the end there's a software product that is developed based on an algorithm. And to be honest with you, I do not represent Google. They're not in my membership, but I do represent companies that want to sell software, to be blunt, at the end. And in my experience, the problem is not that companies do not want to give access, in this sense, to sell software to hospitals, to general practitioners, to patients. But there's a very interesting discussion currently ongoing on reimbursement models for digital health solutions. And how that actually works. If we go away from the more traditional medical software that we already currently have to software that is directly being used by patients, where, by the way, we don't have so many practical examples yet on the market here. So in a lot of member states, actually, Germany, but also others, they're currently changing the way that they are reimbursing software and use of software to actually address that topic.
Thank you, Annika. Thank you, audience. I'm sorry that I took some time from your coffee break. Thank you very much for your attention, and thank you very much, panelists, for your introductions.
Thank you.